A joint select committee of the Parliament has recommended substantial changes to the Personal Data Collection Bill. The 30-member committee, headed by BJP MP PP Chowdhury, tabled its report in both houses of the Parliament on Thursday. The report stressed on the need to have a law on data protection in India and made it clear that India may no longer leave its data to be governed by another country. Overall, the panel made 81 recommendations for modifications, and the draft amended bill has 150 corrections and improvements to various clauses of the Personal Data Protection Bill. The panel has made several recommendations to the government. Let's take a look at some of the big ones. The original bill wanted to establish a data protection authority and address issues arising of the Supreme Court's verdict establishing privacy as a fundamental right. The first recommendation is that all data should be dealt by one data protection authority. Since the bill provides for the establishment of one data protection authority, we cannot have two DPAs, one dealing with privacy and personal data and the other with non-personal data. So that's the biggest change. The Joint Select Committee has included non-personal data to the Personal Data Collection Bill, and so it recommends that the bill be changed to Data Protection Bill 2021. The panel observed that there is a large number of collection, processing and storage of data in India and asked the government to prepare a data localization policy to ensure that data is stored in India. It also said that there should be restricted access to the data and said that it should be categorized as sensitive and critical personal data. It set a 2-year deadline to the government and data fiduciaries to make the needed changes to policy, infrastructure and process. The report had some major recommendations for social media. Firstly, the panel recommended that social media platforms will be classified as significant data fiduciaries as they collect and process data. Secondly, it wants to treat all social media platforms which do not act as intermediaries as publishers. This means that social media platforms can be held accountable for the content they host. It said that a mechanism should be devised by which social media platforms will be held responsible for content, even if it is from unverified sources on the platform. It said that these platforms should not be allowed to operate in India unless the parent company sets up a local office. The third recommendation is that the government set up a statutory media regulatory authority on the lines of the Press Council of India to regulate content on these social media platforms. What should happen if these rules are violated? The panel has made several recommendations on this regard too. It said that penalty provisions should be flexible as the world of digital technology is constantly evolving. If a fiduciary fails to register with the DPA or does not undertake data protection impact assessment or does not conduct a data audit, the penalty could be 5 crore rupees or 2% of its total worldwide turnover of the preceding year, whichever is higher. If there is a violation in processing personal data or if the personal data is transferred outside India, the penalty could be 15 crore rupees or 4% of its total worldwide turnover in the preceding year, whichever is higher. It also said that the head of government department should be made directly responsible in case of a data breach. It said that the fiduciary should make a report of the data breach within 72 hours. It also asked the government to devise a single window system to deal with complaints, penalties and compensation. So, what's next? Well, the suggestions made by the panel are not binding. If the government accepts any of the recommendations of the committee, it can bring amendments at the consideration stage of the bill, or it can withdraw the bill, include the changes and bring the bill back to the House again.